You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Redpot. Possible your client waived the formal reading of the indictment.
You will, Your Honor.
Ms. Vargas, in cause number 26 DCCR 0081, the state has elected to proceed on count 1 only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, it is.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. All right, good luck to you, ma'am. You can go back to the bailiff. Quentin Sells. It's a competency, right?
Yes.
Quentin Sells.
Quentin Bell. Not.
I see you. I'm not sure.
Yes.
Good morning. Are you Quentin Sells?
Yes.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026 also. It is from a Dr. Shahani, also has the same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, no.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil, locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all that conversation.
Right.
With the best of the conversation with our friends.
Right. I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you.
Yeah, you can get out. What you want?
Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge, I think there's another way we can go
Okay,
with this
I agree.
next time.
Johnny Segita or Segata?
I think it's engaged.
Johnny, speak up. Okay. What?
Good morning. Are you Johnny Segata Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we go.
Mr. Segata, in cause number 26, DCCR 0795, you're charged with a second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rowe?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Segate is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay? You can go back with the bailiff. What about Byron Morris? I have it. Let's do Byron Morris.
Byron Morris. Lawrence. Byron
Well, maybe some stuff. Hey. All right.
We have.
Good morning, sir. Are you Byron Jamal Morris?
Yes, no,
And Mr. Rojas, will your client waive the formal reading of the motion?
you will, Your Honor.
Mr. Morris, in cause number 15-21651, you have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
Not true.
Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, Your Honor. True. True.
Count 3 alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court-assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1 and 4. And I'm assuming if there's an officer, even with the public intoxication, it wouldn't be longer than a regular day. We can add it to the end. All right, so we'll set this so that we have time for a couple of witnesses just on a regular Tuesday docket. Anything that you think is important for me to know, make sure you get that to Mr. Rojas, and he'll present it to me on your behalf when you come back.
Yes, ma'am.
Okay, you go back with the bailiff.
Thank you.
Thank you, Judge.
Thank you. Let's show that it was reset.
Yeah.
Mm-hmm.
I was putting up hands to judicial and I'm gonna. I'm sorry.
That's okay.
No.
Okay. Let's see. Okay, Mr. Lewis, you've got Avriona Dorsey.
I think I need to sign that, Your Honor.
Okay, I'll call it as soon as she's ready. Do you need? Oh, she's already doing another one. About Kenneth Harrison. Mr. Lewis.
Harrison. You Harrison.
Harrison. How are you?
Oh, no.
Good morning. Are you Kenneth Harrison? And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first degree felony offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed on or about March 31st of 2026. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count 7, let's see, state abandons 4, 5, and 6. Count 7 alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count 8 alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Roderick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
The question would be underlying offense, Your Honor.
I'm just going to go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. They got caught. One of them fired a shot at that person who confronted him while they were breaking into cars at a parking lot. Put everyone on probation. They've all come back, Judge.
I guess my concern is that there was obviously a gun and a shot in the underlying
I
offense,
do recall Mr. Harrison not being the shooter. I think we were able to figure out who,
but he's in another gun. I mean, another car with somebody
Yes.
with another gun.
and Mr. Randall's been revoked, sentenced to 8 years. He had a drug case, a new felony, so which is why his was a little bit more.
Look at something else. Do you happen to have the PC for that? The new,
There's new event, the
yeah,
I do, Judge.
thank you.
I also have the report from Mr. Randall's charges from the same stop. If you're asking as far as where going was,
Yeah, that's
Mr.
what-
Randall's lap, I see ran from the vehicle and fell into the sea.
Obviously, I'm just having some concern.
I understand her.
Yeah. Obviously, we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was about 6 o'clock in the evening. I don't think it was past.
Oh, it was? Sorry, I thought I read
Well,
something
it's-
about curfew. That was
not this one. Your Honor.
okay. Thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then
That would probably.
There's a-
So it'll have in here.
yes, Your Honor, he's one of the original.
Okay, I'm not gonna,
Defendants.
yeah. Five's not, I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that. But at this point,
We'll discuss it.
I'm over all of this gun stuff. So I'm going to, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to, but I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Go back.
Here it is. We send this one.
Mr. Parker, Dontrell Robertson, you're asking for some more time on that?
Yeah, we're just gonna try to work the case out. It was set for a bond hearing.
Okay,
So we're gonna pass on a bond hearing. We're gonna try to get the case worked out. I
today?
I don't have all the information yet.
Okay,
Get the
so
new case.
we'll reset Dontrell Robertson, just a little bit reset. About Brent Smith.
That should be papers.
Okay, I don't have them yet.
Oh, really?
Do you have papers for Brent Smith? Okay, thanks. We can go ahead and get Mr. Smith. I'll take care of it next. Brent Smith. You need to fingerprint him?
Yes.
Okay. Mr. Smith, if you'll step in front of the clerk first real quick so she can swear you in and take your thumbprint.
Oh, drug course, it's supposed to be substance abuse on the ISF.
Oh, I don't see it yet. It's supposed to be ISF substance.
Yeah, I just put drug.
Oh, okay.
I just said drug.
Oh,
I mean,
I figured you knew what he was talking.
I just thought of that. But yeah. Right.
good morning, sir. Are you Brent Smith?
That's correct. Yes.
And will your client waive the formal reading of the indictment?
Here we go, Your Honor.
Mr. Smith, in cause number 26 DCCR 0128, you're charged with the second-degree felony offense of burglary of a habitation from December 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that this date's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and you would be required to enter and successfully complete the substance abuse track of the ISF program. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. We'll make sure that we have everything in place, in addition to an ISF that you need in order to be successful. And then we'll come back for sentencing at a later date. All right, you can go back with the bailiff. Well, Donald Jeruso.
I didn't pick that foot.
Okay. Okay. Let's do you have a sentencing?
I have Victoria Bailey for
Let's do Victoria Bailey. It's a sentencing.
Victoria, they
Mark Hebert, we just can go through the motion.
Okay. Thank you. Good morning, ma'am. Are you Victoria Bailey?
Yes, ma'am. Good morning.
And Ms. Bailey was previously here in court in cause number 25 GCCR 0278, entered a plea of guilty to the third-degree felony offense of assault on a hospital personnel. And I've received that pre-sentence report. Have you both had an opportunity to review the report?
You have, Your Honor.
Yes, Chief.
Are there any additions or corrections?
Nothing more, Judge.
All right, Ms. Bailey, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include being on the specialized mental health caseload. That'll make sure you have anything you need in order to be successful. So you can get your any drug treatment, mental health treatment, and it's important that you follow through with everything that they recommend. Even if you don't think it's necessary, it's going to be court ordered that you go through whatever program probation says you need to, okay?
Yes, ma'am.
This is a great opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have a felony conviction. So it's a great opportunity.
Yes, ma'am.
The other side of that opportunity, though, is that if you violate any condition of probation, you can be brought back into court and you can be found guilty and sent to the prison for between 2 years and up to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. It looks like I will be signing also a dismissal in clause number 25 DCCR 0170 as part of that agreement. All right. Good luck to you, ma'am.
Thank you. Thank you so much.
So Mark Hebert's the one we're just going through the motions. Mark Hebert.
Mark,
In the end, the judge chose caution over speed. Rather than rushing into a final sentence, the court demanded more facts before deciding whether this defendant deserved another chance, or whether prison was now unavoidable. Cases like this remind us that every courtroom decision balances justice, public safety, and the possibility of redemption. Stay tuned, because the final outcome could change everything.